The Securities and Exchange Commission sued Coinbase, the largest cryptocurrency trading platform in the United States. They filed that lawsuit today. The SEC accuses Coinbase of breaking market rules by allowing users to trade unregistered securities. Now, this comes a day after the SEC accused the crypto platform Binance of mishandling funds. President Joe Biden is awarding $115 million to support needed investments to rebuild Jackson, Mississippi's water infrastructure. The federal dollars are part of a $600 million appropriations funding approved by Congress last year. Jackson, a majority Black city of nearly 150,000 residents, is in a state of rebuilding after its water system nearly collapsed last summer due to major flooding and years of infrastructure neglect. A Texas sheriff's office has recommended that a San Antonio area district attorney file criminal charges following an investigation into the transportation in the fall of 49 asylum seekers from Texas to Martha's Vineyard in Massachusetts. Now, allegedly, these migrants were sent to Martha's Vineyard at the direction of Florida Governor Ron DeSantis. It's not clear whom the charges would be filed against, but the case would include both felony and misdemeanor charges of unlawful restraint. State officials in Oklahoma approved the local Roman Catholic Archdiocese request to operate a public charter school. This will be the first explicitly religious public school in the United States in modern times. Supporters of the school hope to use it as a test case to take to the Supreme Court and win a clear right for public schools to offer religious instruction. The 2024 GOP field keeps growing. This week, adding 3 new candidates. Chris Christie and Doug Burgum are set to announce their presidential campaigns this week, and Mike Pence has already filed his paperwork. As Chris Christie enters the race, he has cast himself as the only candidate unafraid to give voice to the frustrations of Republicans who've watched Donald Trump transform the party and who have had enough either of the ideological direction or the years of compounding electoral losses. 3 women who claim Cuba Gooding Jr. sexually abused them, including one who was upset that she never got her day in court when Gooding resolved criminal charges without trial or jail, were prepared to testify at a federal civil trial today to support a woman's claim that the actor raped her in 2013. Now, the case settled before the trial could begin. House Judiciary Committee Chairman Jim Jordan, a top Trump ally, is calling on the Justice Department to provide lawmakers with internal documents which lay out the scope of Special Counsel Jack Smith's investigation into the former president's handling of classified documents found last year at his Mar-a-Lago estate in Florida. Well, America's state capitals are as polarized as they have been in decades, with lawmakers imposing unflinchingly conservative or liberal agendas this year, even in politically diverse places. The 2022 election brought single-party control of the governor's office and legislature to 39 states, the most in at least 3 decades. You're listening to Areva Martin in real time, and I'm your host, Areva Martin. This is your one-stop destination for today's trending news, expert analysis, and my unfiltered opinions. This is hour 2 of Areva Martin in real times, and this is the hour where we go behind the headlines. Today, I have a career prosecutor here who's going to help us make sense of the motions and the replies to those motions filed in the case of Mark Ridley Thomas. Mark Ridley Thomas's legal team is requesting that the guilty verdict against him be set aside. And he's also requesting that the federal district judge grant him a new trial. Now, some legal experts say this is hoping against all hope, and that it is nearly impossible to set aside a verdict in a federal criminal trial, and that getting even a new case is going to be a Herculean effort. When we come forward, I talked to career prosecutor Bobby Grace, who has seen his share of these types of motions and the kinds of replies that were filed by the prosecutors. I get Bobby Grace's take on whether Mark Ridley Thomas's legal team has filed persuasive documents and whether they are likely to be successful at the upcoming June 26th hearing. Stay with us. KBLA Talk 1580.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The three people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me. And the reason why I have such respect for what you do is you have a historically informed conversation of depth and detail.
Be sure to tune in to Tavis Smiley weekday mornings, 9 a.m. to 12 noon on your unapologetically progressive radio station, KBLA Talk 1580. KBLA Talk 1580.
Is the pen mightier than the sword?
They say the pen is mightier than the sword. At KBLA Talk 1580, we not only have a lot to talk about, we have a lot to write about. Politics, relationships, business, empowerment, and culture. The all-star roster at KBLA Talk 1580 has you covered.
That's what it's all about.
Be sure to follow us on all our socials for our latest book releases, op-eds, essays, and commentaries from our hosts. And, of course, download the KBLA 1580 app as we strive to remain your most trusted, credible, and reliable source for the issues you care about. This is unapologetically progressive. KBLA Talk 1580.
What up, baby?
I'm young, gifted, and black. KBLA Talk 1580, we do more than just talk.
Hey there, I'm Jared Hill, president of the National Association of Black Journalists of Los Angeles, and I just want to say thank you for the benevolent $10,000 donation in scholarships for the next generation of black journalists.
And I'm Haywood Galbraith, photojournalist and founder of the Minority Photojournalism Institute. Thanks, KBLA, for your generous $10,000 scholarship gift to help us train the next generation of black photojournalists.
Congratulations to all the students who will benefit from the scholarship dollars raised at our Black History Month luncheon, honoring black legends in LA media. When we come forward at KBLA Talk 1580, we're bringing everybody with us. Everybody with us. Everybody with us. Everybody with us.
Connection established. Access granted.
In a survey conducted by the public opinion research firm Eviterus, KBLA Talk 1580 consistently emerged as the station of choice for black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of black audiences are concerned about the lack of black-owned media and are more likely to listen to talk radio that focuses on issues that impact the black community. For some reason, the other talk stations haven't quite figured that out.
If you think about KFI, well, KFI only has like a 3% black listenership. 3%. So there's a good 97% out there to support a station like KBLA.
At KBLA Talk 1580, we've got your black. Your black. Your black.
Follow the leader.
KBLA Talk 1580.
Follow the leader.
Be sure to follow us on Instagram at KBLA 1580.
Many in the Los Angeles and broader California community were rocked on March 30 when a federal jury convicted Mark Ridley Thomas, former Los Angeles City Council member and former LA County supervisor, as well as a former state legislator. He was convicted of 7 counts related to contracts and dealings with the USC, that's University of Southern California, School of Social Work. Now, although Mark Ridley Thomas was acquitted of 12 charges, the jury found him guilty of conspiracy, bribery, and mail and wire fraud. Sentencing in that case is scheduled for August 21st. Now, if you think that was the end of the story, then you don't know Mark Ridley Thomas. As has been the case since he was indicted in October of 2021, Mark Ridley Thomas has continued to challenge the convictions with a pair of legal filings filed several weeks ago before Judge Dale S. Fisher. Both claim that there were numerous problems with the prosecution's case, and they asked the court to basically scotch the decision. One motion asked the judge to vacate the verdict and order a new trial. The other motion calls for her to deliver a judgment of acquittal. Mark Ridley Thomas is represented by the legal team at a very prestigious international law firm, Morrison and Foerster. And they have filed 2 briefs with an arsenal of arguments. The 33-page motion requesting a new trial asserts that FBI agent Brian Atkins, who served as the prosecutor's star witness, gave a false statement that helped swing the verdict. There's no subtlety in the section of the document titled "Multiple Errors Infected the Jury's Deliberations and Denied Dr. Ridley Thomas a fair trial." Now, in the separate 37-page motion pushing for acquittal, also that motion takes swipes at the prosecution and its star witness, FBI agent Atkins. In that motion, they charge that Atkins never had a full understanding of how the county government operates and that one powerful figure can't mash through a contract with zero oversight. We know that the government did not call a single witness from LA County to testify in its case. The filing also charges that the government didn't prove an essential element of its case, and that is that the government didn't prove any quid pro quo. Now, Judge Fisher will have Mark Ridley Thomas's legal team in her courtroom on June 26th. That is the same date that the judge has set for the sentencing of former dean of USC, Marilyn Flynn, the person who is really at the heart of this entire case. She pled guilty last year to 1 count of bribery. And the question we're asking career prosecutor Bobby Grace today is, will the arguments made by Mark Ridley Thomas's legal team, will they resonate with Judge Fisher? We know that generally it is an uphill battle to have a verdict set aside in a federal criminal case such as this. But we know when it comes to Mark Ridley Thomas, often the exception is the rule. Welcome, Bobby, and thank you for joining me again. You have been a trusted source of legal analysis and information on this case since we started covering it back at the beginning of March. And I appreciate you being here today to help us make sense of these motions, these very lengthy motions filed both by Mark Ridley Thomas's legal team and the opposition, also very lengthy opposition filed by the prosecutors. Let's start with Mark Ridley Thomas's motions. Let's start with the motion for a new trial. What are your thoughts about it in terms of it, the substance and the likelihood that it might be persuasive enough for the judge to consider granting a new trial?
Good afternoon, Areva. Thank you for having me, as always. So you kind of laid out the uphill battle that Mark Ridley Thomas's team is facing, but you also laid out the fact that the documents that were filed by his legal team are somewhat persuasive, and I'm going to tell you why. As you laid out in your introduction, the main witness who didn't testify but has kind of been brought up is Marilyn Flynn, the USC dean, who is the other side of the bribery part of all this, right?
Right.
The Mark Ridley Thomas's team effectively lay out that there was really no proof through any direct evidence that there was a quid pro quo between Mark Ridley Thomas and Marilyn Flynn. And in fact, in conspiracy cases and bribery cases like this, it's very unusual for the prosecution, either on the state or the federal level, to take a plea deal with someone and then not have that person testify in court, which did not happen here. And it's very,
Let me stop you there, Bobby. That's such a great point. And so many people asked that question as we were providing that gavel to gavel trial coverage throughout this case. Folks ask, how come the prosecutors, when they cut the deal with Marilyn Flynn for her to plead guilty to one bribery charge, why didn't they demand in that deal that she become a witness for the prosecution, which is, as you said, typically how these deals work when someone enters into a plea deal with the government. Obviously, they're trying to get a more lenient sentence. They're trying to curry favor with the government, and the government typically wants something back from them, like help us make the case against the other person, the other part of this conspiracy case that is going to trial. Why do you think they didn't demand that of Marilyn Flynn in this case?
Well, the only thing that I can surmise, Areva, is that if she were called to the stand, she wouldn't have said what the prosecutors were alleging or what they wanted her to say. We know that there were other things that she was alleged to have done with respect to her stewardship of the dean of social welfare at USC. And in fact, her plea may be based on other charges that we're not aware of.
So you're saying she may have pleaded guilty to something totally unrelated to Mark Ridley Thomas?
That's a strong possibility because the federal government just does not enter into plea agreements with people without having them spell out exactly what they're guilty of. They have to allocate. And in 99.9% of the cases, they have to testify against the other people that were involved in their crimes. And that did not happen here. So I have to surmise that Ms. Flynn would not have testified the way that they wanted her to in order to try to get a conviction against Mark Ridley Thomas.
Let me ask you this, Bobby. Even though they didn't require her in that agreement, when you do that as a prosecutor, enter into a plea agreement, don't require that individual to testify, can you still issue a subpoena? Like, could they have gotten halfway through their case and decided, hey, this isn't going well. We do need Marilyn Flynn. We know it's a risk. We know she's not the best witness for us. So we're going to issue a subpoena for her. Could they have done that?
They could have, but as you closely follow this trial, and I don't think that the way that they set up their case really put in the structure that Flynn would be testifying. And so to come in at the last minute and have her come in as a witness to say, who knows what she would have said. And the federal government, Areva, they do not put on witnesses that they don't know exactly what they're going to say. And with the odds that it's going to really bolster their case. So I just don't think on any front, any count, that they felt that Flynn would be a productive witness for them.
Okay, so let's go back to, you were saying, reading these motions, this motion for a new trial, you said there's some substance there, something that resonated with you, and you were making mention of the fact that Marilyn Flynn did not testify. She's the other side of this alleged quid pro quo, and we did not get to hear her testimony. So tell us what Mark Ridley Thomas's legal team made of that in its motion that you think is substantial.
Well, in their motion, as you kind of laid out, also in your introduction, they talk about how the FBI agent didn't understand county government, and that he wasn't qualified really to testify as to his view as to why there was a quid pro quo between Mark Ridley Thomas and Marilyn Flynn. And in fact, much of the prosecution's case, which they kind of go back to in their response to Mark Ridley Thomas's team asking for either acquittal or a new trial, they refer to text messages between Mark Ridley Thomas and Marilyn Flynn, which ultimately the FBI agent was left to kind of tell the jury what he thought the text messages meant. That's kind of unusual in any criminal case, and definitely unusual for a federal prosecution. You would want to have a witness that would explain everything that's in the text messages, and ideally somebody that's in the heart of the deal, part of the conspiracy, part of the bribery. That didn't happen here. And so there's a very, very good arguments that the Mark Ridley Thomas's team made in their moving papers. Now, to go back to your original point, yes, it is an uphill battle because remember, they're arguing to the judge that was listening to all the evidence. And if she had agreed, then she should have called for an acquittal at the close of the prosecution's case. Let
me ask you this. Let me stop you, Bobby, because you keep raising these really good points. The text, so the prosecution in its opposition, its reply to the government and to Mark Ridley Thomas's team's moving papers, their motions, they resort back to what their case is. They kind of reiterate what the evidence is. This is the only evidence that's available to them to argue. So they go back to arguing that. But it begs the question, as you just said, that typically you wouldn't see a case put on about text messages back and forward from A to B without having A or B testifying. In this case, we had text messages between A and B, and then C comes in, is trying to interpret what those text messages between A and B means. And C wasn't there at the time that the text messages were sent. C talked maybe to A, but we know C didn't talk to B. So C is only left with, whatever he can surmise based on the conversation with A. And perhaps A, as you said, didn't tell C what C wanted to hear, because otherwise they would have had A come in and testify. Why were those text messages that are so critical to the government's case, why were they allowed in? Because that's also, we'll get to that, a part of what the prosecution says is, look, Mark Ridley Thomas's legal team was incompetent, and they should have been objecting more. And if they didn't object to try to keep some of this evidence out, they can't be heard to complain now. Basically, they have to live with their own incompetence. I'm just paraphrasing kind of what their the government's reply motions say. But why were those text messages allowed to be interpreted by C? And C in this case was the FBI agent.
Well, the argument from the prosecutors was that the text messages were, if you will, plain on its face, that the bribery is there for everybody to see and that a layperson could interpret it. But, we do have the FBI agent that can kind of spell it out also in layperson's terms. He's not an expert. He didn't work for the Board of Supervisors. He doesn't work within county government. So I don't think in any way, shape, or form, he could have been viewed as an expert. But he could, as a layperson, say what a layperson's view of the text messages between Mark Ridley Thomas and Marilyn Flynn meant. That's one of the major problems with the case. Much of what the prosecution alleged against Mark Ridley Thomas was not found to be true by the jury. The only thing that's really left in this case is the one vote with respect to the county contract, which is the whole basis of the honest services conviction of Mark Ridley Thomas. And one key point here, Areva, that a lot of people may not be watching is that there have been a few Supreme Court decisions recently that overturned convictions by the federal government for this same honest services prosecution or bribery, if you will. And the Supreme Court is saying that this whole law with respect to honest services is confusing and that it's very difficult to convict someone under this. And this doesn't bode well down the road if this holds up in terms of a conviction and actual sentence of Mark Ridley Thomas. I think he stands a really good chance of getting the conviction overturned on appeal because of these recent decisions by the United States Supreme Court.
Yeah, one of the things that really got me confused, Bobby, and you'll remember this, when this case first hit the news, there were allegations that the contract involved, that the so-called quid pro quo contract, was a $8 million contract. That in exchange for an $8 million contract that was given to USC School of Social Work, Mark Ridley Thomas was getting his son, Sebastian Ridley Thomas, into USC with a scholarship, and he was getting a job, and he was getting this favorable treatment, a fast-track admission into a graduate program, scholarship, and job. And in exchange, USC was getting an $8 million contract. Now, we know things that are said in the court of public opinion often aren't the evidence, is not the evidence that's introduced in court. And boy, is that ever true in this case. So we went from being told for months and months that it was $8 million and it was so salacious and it seemed so horrible, like, oh my God, $8 million, to when we got down to it in court, Bobby, it was a $545,000 contract. And what Mark Ridley Thomas's legal team argues in their papers is that contract for $545,000 had already been exhausted. So by the time
that's a big part of this, Areva. That's a big part of
spinning, Bobby. I was like,
yes.
Wait a minute.
Yeah. This is a big part of it.
We're not 545,000. We're down to zero.
Yeah, that's a big part of it. That what they were alleging never really was voted on in the manner that they alleged. And there's a strong argument that Mark Ridley Thomas was going to vote yes for this particular deal because he already voted yes in other parts of it that had already been in front of the county, which I don't know that the FBI agent really understood. So that's another part of the argument that MRT's team is going to be making when they get their chance to argue.
Yeah, that part of it really, I felt like we had been hoodwinked. I felt like the public had been misled by the mainstream media and even by the government. And when we come forward, I want to ask you as a prosecutor, how can a prosecutorial team working for the Department of Justice, federal, office, put forth a case that is seemingly so shoddy and so bereft of actual facts? It just feels like this whole case was built on a misunderstanding of the facts and even a misrepresentation of the facts. Stay with us. KBLA Talk 1580. More on the federal bribery trial of Mark Ridley Thomas when we come forward.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The three people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me. And the reason why I have such respect for what you do is you have a historically informed conversation of depth and detail.
Be sure to tune in to Tavis Smiley weekday mornings, 9 a.m. to 12 noon on your unapologetically progressive radio station, KBLA Talk 1580.
KBLA Talk 1580. Is the pen mightier than the sword?
They say the pen is mightier than the sword. At KBLA Talk 1580, we not only have a lot to talk about, we have a lot to write about. Politics, relationships, business, empowerment, and culture. The all-star roster at KBLA Talk 1580 has you covered.
That's what it's all about.
Be sure to follow us on all our socials for our latest book releases, op-eds, essays, and commentaries from our hosts. And, of course, download the KBLA 1580 app as we strive to remain your most trusted, credible, and reliable source for the issues you care about. This is unapologetically progressive. KBLA Talk 1580.
What up, baby?
I'm young, gifted, and black. At KBLA Talk 1580, we do more than just talk.
Hey there, I'm Jared Hill, president of the National Association of Black Journalists of Los Angeles, and I just want to say thank you for the benevolent $10,000 donation and scholarships for the next generation of black journalists.
And I'm Haywood Galbraith, photojournalist and founder of the Minority Photojournalism Institute. Thanks, KBLA, for your generous $10,000 scholarship gift to help us train the next generation of black photojournalists.
Congratulations to all the students who will benefit from the scholarship dollars raised at our Black History Month luncheon, honoring black legends in LA media. When we come forward at KBLA Talk 1580, we're bringing everybody with us. Everybody with us. Everybody with us. Everybody with us.
Connection established. Access granted.
In a survey conducted by the public opinion research firm Eviderus, KBLA Talk 1580 consistently emerged as the station of choice for black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of black audiences are concerned about the lack of black-owned media and are more likely to listen to talk radio that focuses on issues that impact the black community. For some reason, the other talk stations haven't quite figured that out.
If you think about KFI, well, KFI only has like a 3% black listenership. 3%. So there's a good 97% out there to support a station like KBLA.
At KBLA Talk 1580, we've got your black. Your black. Your black.
Follow the leader. KBLA
Follow us on Instagram at KBLA 1580.
Follow the leader.
Are you ready?
The station leading the way with exclusive interviews,
Follow the leader.
stimulating conversation, and intellectual discourse that empowers, enlightens, and informs.
Follow the leader.
Follow the leader at KBLA 1580.
We've got a lot to talk about.
Keep following the leader.
Follow the leader. Follow the leader. Follow the leader. Follow the leader. Follow the leader.
Gotta stay fresh, ma. House shot with a rest spot.
Have you visited us online for the grand opening of KBLA.store? For the best in new merch, gift ideas, books, media, and more, log on to KBLA.store. Be sure to check out our KBLA team favorites at KBLA.store today. That's KBLA.store for all the official merch on your favorite talk radio station, KBLA Talk 1580.
The bounce is back.
Race, social justice, sports, politics, art, music, culture. We do it all on the D.L. Hughley Afternoon Show. If you're not tuning in, then you are definitely missing out. It's the D.L. Hughley Afternoon Show, weekdays from 2 to 4 only on unapologetically progressive KBLA Talk 1580.
Like a brand new flavor in your head.
This is a rather bold pronouncement, but we think we can back it up. If you come across a radio frequency anywhere putting more variety and more diversity on the air than KBLA Talk 1580, we sure would like to hear about your discovery.
You got to have vision.
You can search, but we are confident that you won't find more shows covering more topics, hosted by a more diverse and inclusive lineup of talkers than the squad we have assembled here at KBLA Talk 1580.
This is the time, brothers. This is the time.
We've got something for everybody.
That's right.
Health and healing, history and humor, issues and events, empowerment and entertainment, all in one station.
What's really going on?
Free enterprise, you dig?
KBLA Talk 1580.
Yes.
Oh yeah. We got a lot to talk about.
King Kong ain't got on me.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The three people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me.
I'm back, and it's hour 2 of Areva Martin in real time. And in this hour, I go behind the headlines and dig deep into the stories that have people talking. And in this hour, I'm talking to veteran prosecutor Bobby Grace about the motions that were filed by former LA City Council member Mark Ridley Thomas. His legal team filed 2 pretty substantial motions asking that he be granted a new trial in the federal bribery case that concluded almost a month ago, and that the guilty verdict be set aside. And it's important to note that the guilty verdict of Mark Ridley Thomas devastated, I would say, thousands of people in the Los Angeles community. I heard from politicians and community leaders and everyday citizens throughout the city of Los Angeles who just felt that the verdict was patently unfair. They were aghast that an African-American elected official with a lengthy record of achievement, such as Mark Ridley Thomas, had been taken down for supporting the kind of community benefiting projects that he had worked on for more than 30 years, really throughout his entire professional career. That's the reason that after that verdict, Bobby, we saw public figures, including the recently elected mayor of Los Angeles, Karen Bass, come out with public statements extolling Mark Ridley Thomas and praising him for his commitment to service. This wasn't your everyday bribery case. This wasn't a guy that had taken money. This wasn't about private jets or expensive gifts or casino chips in Las Vegas. There was no money exchanged in this case at all. Mark Ridley Thomas received no monetary benefit. The only benefit at issue was allegedly a benefit to his son, again, Sebastian Ridley Thomas, who was more than qualified to be admitted to USC's Graduate School of Social Work, a graduate of Morehouse College, a very accomplished elected official in his own right, gets admitted to the School of Social Work. and gets a job as a professional, that is similar to so many others that we've seen who leave political office, who go to work at institutions like USC. So for many of us in the community, we just thought this was an unfair targeting by the prosecution of a very, very effective African-American elected official. And then we see the prosecution's case, Bobby, a case where they didn't call one witness from the county of Los Angeles. They didn't call one employee that worked in Mark Ridley Thomas's office who had dealt with Marilyn Flynn. Even the employee who received the so-called smoking gun letter that was hand-delivered by Marilyn Flynn's team, that the prosecution made such a big deal out of this confidential letter. Those employees were called in the case of Mark Ridley Thomas. So let's, again, talk about these motions. We know traditionally there's the uphill battle, but you just identified these Supreme Court cases that may make it difficult for the prosecution's case to withstand scrutiny, at least on appeal. But I want to ask you about the reply filed by the prosecution. They really go after lead counsel, this Morrison and Forrester, very accomplished attorney. They call her a patent lawyer. They say she was out of her lane. They say she, didn't know how to prosecute effectively a criminal case of this nature, and basically say, look, you lost the case because you were incompetent. What do you make of that argument, Bobby?
Well, Reva, I'm very disappointed when lawyers on either side resort to name calling or, talking in personal terms about lawyers. You should be sticking to, what the strength and weaknesses of the other side's case are. If there were strengths, you need to be trying to tear those down with your arguments. Or if there are weaknesses, then you need to bolster your own arguments. And I think you're on dangerous ground whenever you're trying to reference the attorneys. And so I mean, they
go as far as to say he had ineffective assistance of counsel. Explain what that means to the layperson. I mean, that's a pretty, salacious charge by the prosecution.
Basically, it means that you hired a bad deal, a person to represent you in court, and that they didn't do a very good job. And again, you just don't want either side to be talking about the merits of the attorneys in the case. Just, if you're resorting to that, then that means that your own arguments in support of your own case are not as solid as you would think.
What do you, absolutely, and we should just remind the listeners and viewers, these lawyers, Morrison and Forrester, one of the most well-respected, national law firms in this country, and they did get an acquittal on 12 counts of this 19-count indictment. So it wasn't as if, we're not talking about folks who didn't know what they were doing. And it wasn't just the lead attorney, who is a patent attorney by training or by practice, I should say. There was a team of lawyers from Morrison and Forrester, including some super experienced criminal lawyers, lawyers from some of the best law schools in this country. So this was not some inexperienced legal team that did not know what it was doing. So I don't know where that argument goes. But let's talk about the jury. We learned something, Bobby, about how the jury viewed this case because the foreperson gave an interview to the Los Angeles Times, and she made it clear in that interview that a deciding factor in the guilty verdict was the $100,000 that Mark Ridley Thomas had directed from a campaign account through USC, with the money then flowing to a nonprofit that was going to be run by his son. They say that action plus the email from Mark Ridley Thomas asking Flynn to, dispatch the check with, some dispatch it, yes, hastily, speedily, quickly. They say that was the deciding factor, but we know that there was an expert witness for Mark Ridley Thomas who said that $100,000 contribution to USC and the routing of that $100,000 to the nonprofit to be run by his son was not illegal. that it was in fact legal. Now, it might have been against USC's internal policies, but there was nothing illegal about it. And the prosecution never countered that argument. They were never able to bring forth an expert to prove or to establish that there was anything illegal about that payment. How do you think that argument is going to factor into the judge's decision with respect to these two motions?
Well, I think the judge is going to have to deal with that particular aspect of it. And in her ruling, she's going to have to kind of go in and say, okay, this is what the actual bribery that we're talking about, or quid pro quo, what it is really is not the passing through of the money through USC. It was Mark Ridley Thomas's vote for getting his son to do this. So the actual doing of it wasn't illegal. It's the bribery aspect of it, if you will. If it's in fact true that Mark Ridley Thomas voted the way that he did because of USC taking this particular route.
But let's go back to the contract. Again, that's what really is hanging me up about this case. As I said earlier in the show, the $8 million, that turned out to be just a complete misstatement, misrepresentation of the facts. There never was an $8 million contract that even the government tried to present. They had no evidence of that. And Mark Ridley Thomas's legal team argues that even the $545,000 contract had been exhausted. So these contracts are rolling. So you have a contract up to a certain amount, and then you bill your services. So this was a telehealth contract. So monthly, as the telehealth services were being provided by the School of Social Work, they were billing the county, and they get to bill up to a certain amount. And in this case, they got to bill up to the $545,000. And when you hit that limit, then you no longer have any funds left in that contract to which to draw down from. So essentially, there's zero left on the contract. When we come forward, I want to ask you, what is the judge going to do if she believes, as the evidence was presented by Mark Ridley Thomas's legal team, that there was no money even left in this contract? So is there bribery if I'm voting on a contract where there's zero monetary value being provided to the other party in this alleged bribery scheme, in this case, USC School of Social Work? When we come forward, more with Bobby Grace on the federal bribery trial of Mark Ridley Thomas. KBLA Talk 1580.
Access granted.
In a survey conducted by the public opinion research firm Eviderus, KBLA Talk 1580 consistently emerged as the station of choice for Black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of Black audiences are concerned about the lack of Black-owned media and are more likely to listen to talk radio that focuses on issues that impact the Black community. For some reason, the other talk stations haven't quite figured that out.
If you think about KFI, well, KFI only has like a 3% Black listenership. 3%. So there's a good 97% out there to support a station like KBLA.
At KBLA Talk 1580, we've got your Black. Your Black. Your Black.
Follow the leader.
KBLA Talk 1580.
Follow the leader.
Be sure to follow us on Instagram at KBLA 1580.
Follow the leader.
Are you ready?
The station leading the way with exclusive interviews,
Follow the leader.
stimulating conversation, and intellectual discourse that empowers, enlightens, and informs.
Follow the leader.
Follow the leader at KBLA 1580.
We've got a lot to talk about.
Keep following the leader.
Follow the leader. Follow the leader. Follow the leader. Follow the leader. Follow the leader.
Gotta stay fresh, my house shot with a rest bar, shot with a rest bar, shot with a rest bar.
Have you visited us online for the grand opening of KBLA.store? For the best in new merch, gift ideas, books, media, and more, log on to KBLA.store. Be sure to check out our KBLA team favorites at KBLA.store today. That's KBLA.store for all the official merch on your favorite talk radio station, KBLA Talk 1580.
The bounce is back.
Here comes the brand new flavor in your head.
Race, social justice, sports, politics, art, music, culture. We do it all on the D.L. Hughley Afternoon Show. If you're not tuning in, then you are definitely missing out. It's the D.L. Hughley Afternoon Show, weekdays from 2 to 4, only on unapologetically progressive KBLA Talk 1580.
Like a brand new flavor in your head.
This is a rather bold pronouncement, but we think we can back it up. If you come across a radio frequency anywhere putting more variety and more diversity on the air than KBLA Talk 1580, we sure would like to hear about your discovery.
You got to have vision.
You can search, but we are confident that you won't find more shows covering more topics, hosted by a more diverse and inclusive lineup of talkers than the squad we have assembled here at KBLA Talk 1580.
This is the time, brothers. This is the time.
We've got something for everybody.
That's right.
Health and healing, history and humor, issues and events, empowerment and entertainment, all in one station.
What's really going on?
Free enterprise, you dig?
KBLA Talk 1580.
Yes.
Oh yeah. We got a lot to talk about.
King Kong ain't got on me.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out.
So, Bobby, the question I'm still trying to get an answer to is how might the judge deal with this issue of the value of the contract? And will that also come into play when the judge, moves forward with the sentencing hearing in August? Because obviously, had there been an $8 million contract at issue in this case, it might have ramifications for one sentence versus if the legal team of Mark Ridley Thomas is correct, that by the time this vote took place, the contract was basically exhausted. I'm sure that has to have other implications for how the judge might consider both the motions for a new trial and for setting aside the verdict as well as sentencing.
Let's take sentencing first, Areva. So in any federal bribery charge, the amount of money that's involved always plays a part in terms of the sentencing. So it would help Mark Ridley Thomas if, in fact, there was very little money involved in the so-called bribery aspect of all of this. And it should bode well for him in terms of the sentencing. To the other part of it.
But let me stop you on that, the sentencing.
Okay.
So you said it'll bode well for him. Give us some range, if in terms of federal sentencing guidelines in this kind of case, are there maximum minimums? Will the judge have complete discretion? And based on there being, very little money involved, what might you think, or what do you think that sentence might look like?
So there are minimums, federal minimums and maximums with respect to this. There are guidelines, federal guidelines that are very strict. Because of the fact that he was convicted of conspiracy and bribery in relationship to the overall case, he would be sentenced to some time in custody. The hope would be that it would be on the minimum side. And given his long tenure in government, his absolute fantastic service to the Los Angeles community in both state, federal, not state, but state and local government, he would get credit for all that, Areva. And I would think that given the way the Supreme Court has been ruling in this particular area, the minimum amount of time would be suggested here in terms of sentencing.
Mm-hmm. And do you have any sense about what those minimums are? Are we talking 6 months, 18 months? 24 months, because we know there's a recommendation of some kind of home confinement for Marilyn Flynn. Now, obviously, she pled guilty and the rules are different, obviously, when someone takes a plea deal rather than, proceed to trial. But assuming the recommendation from Marilyn Flynn is 6 months home confinement, just based on your years of experience, I know you don't have a crystal ball. You can't look at what this judge is going to do. I know there's a whole, pre-sentencing report that has to be done, but just based on your experience, what's your gut telling you the number is in a case like this?
I would think that it would be somewhere with federal guidelines now. He would have to do federal custody in the range of about 20 to 30 months in what I would think would be some kind of minimal security facility. That would be my guess.
Okay. And so you were going to respond to, I stopped you to ask you about the sentencing, but let's go back to the motions themselves, assuming that there's very little money left in these contracts. It's not the $8 million. It's not even the $545,000. How do you think that plays into the motion for a new trial and the motion to set aside the verdict?
Well, so Judge Fisher is going to have to determine whether there was some value there for the quid pro quo. And the prosecution's argument would be that, yes, we had argued earlier that it was $8 million. We were wrong. And it's probably because they didn't have a good understanding of county rules and how county contracts work. But the argument would be from the prosecutors is that this was an ongoing contract that would renew at some level of money, and that really what we're talking about was Mark Ridley Thomas's support for the overall idea that the probation department would be working with the USC School of Welfare. And so that's the true value, would be the prosecutor's argument. Areva, you kind of laid out what the Mark Ridley Thomas's team was, that this was something that, because it was ongoing, Mark Ridley Thomas had already voted for this, and that because of Mark Ridley Thomas's long-standing relationship with USC, really all he was doing was asking USC to do a favor for his son, which wasn't illegal. And if you view it in those terms, there's a strong argument that Mark Ridley Thomas did nothing wrong here. On the flip side, the specter of the son getting a scholarship in the backdrop of the whole, it wasn't just USC, but other schools with the scandal about people getting into school for money. I think, it just didn't look good at the start of the case, as you kind of laid out. But when everything played out, it all comes down to this one thing, scholarship for Mark Ridley Thomas and a pass-through the nonprofit, which isn't of itself illegal. So when you really boil all this down, some people are probably asking, what really did Mark Ridley Thomas do, which was illegal?
Yeah, I think, again, so many of us are scratching our head trying to figure out how a case that on the facts where the government doesn't even understand the mechanisms of county government, how a case gets this far, and given someone who had such a long-standing relationship with this university and the university was in his district and his job was to provide contracts to serve the marginalized community in his district. That's what elected officials are, elected to do. And so they do it in this context. And, these private universities have all of these VIP programs where they accept various members into their graduate programs because it's prestigious for them. It's prestigious that a former elected official is on your faculty. It's prestigious that a former, governor is on your faculty. So again, his son, so well qualified to be accepted into USC, irrespective of whatever was going on with his dad. It's just hard to see how the government was able to put together this case. I do want to ask you, though, Bobby, the court, you mentioned these recent Supreme Court cases that really call into question honest service mail fraud and how difficult it's going to be for prosecutions to move forward in prosecuting some of these cases. How much do you think the judge is going to be thinking about those cases, thinking about what happens on appeal as she's reviewing these motions, hearing the arguments, and ultimately making her decisions?
I think she's going to try to stay in her lane. And because, again, she presided over the case and she had an opportunity to dismiss it at the close of the prosecution case, and she didn't, then it kind of tends toward her sticking with her initial perceptions of all this and sticking with the guilty verdicts that came out. But again, this is a case that had a lot of twists and turns. And as we pointed out, probably what the prosecutors thought they were working with initially when the case was originally filed, something happened. And they lost a piece or big pieces of what they thought were going to be their case. It didn't come to fruition for whatever reasons. That includes Marilyn Flynn not being a witness here. So I think there are opportunities here for the judge to do something unprecedented, which would be to either grant a new trial or dismiss the case outright.
In a case where a judge does grant a new trial, again, you mentioned, I think you're right on the money when you say something happened in this case. From the time they got the referral and we're like, oh my God, this is going to continue our legacy of bringing down these big, powerful Los Angeles elected officials who are involved in all of this corruption, to the time they got to the courthouse, their case had lost something really big, something very significant. Knowing that if a new trial is granted, what does the prosecution do? Because they got to go back to court with that same case.
Well, I think either they would have to convince Marilyn Flynn to become a witness. And again, we don't know what she would have said. We're all speculating here, guessing that she wouldn't have been good for the prosecutor. So that may not be a good route for them to go, to try to get her to come in. But they would have to get somebody to come in and say, you know, outright that Mark Ridley Thomas had done something illegal. And given the posture of the case and the way things go, I don't know that they'd be able to do it.
Wow. Yeah, lots of unknowns. June 26th, these motions filed by Mark Ridley Thomas's legal team will be heard in the courtroom of the same judge that presided over the trial. She'll have to contend with these arguments, very persuasive, very powerful arguments made by the legal team for Mark Ridley Thomas. She'll have to obviously take into consideration the opposition motions filed by the prosecutors. And on that same date, she is going to issue her sentence for the former dean of USC Social School, Marilyn Flynn. We will continue to provide gavel-to-gavel coverage of the federal bribery trial of Mark Ridley Thomas. We'll have our veteran prosecutor, Bobby Grace, back with us, as well as some of the others in our legal panel who've been helping us break down this case and to understand the nuances and the intricacies of a federal bribery trial. Thank you so much, Bobby, for your time today. And that's it for Areva Martin in Real Time. The next voice that you hear will be Robin Ayers and the Raw Report right here on KBLA Talk 1580.
Access granted.
In a survey conducted by the public opinion research firm Eviderus, KBLA Talk 1580 consistently emerged as the station of choice for Black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of Black audiences are concerned about the lack of Black-owned media